Hello, everybody. Welcome to today's webinar. My name is Elizabeth Gallagher, Liz, and I'm a paralegal here at Lyles Parker. So thank you all for joining us for today's webinar series hosted in conjunction with the Home Care Association of Louisiana. Before we get started, I have Dr. Warren Hebert here on the line as well. You probably know who he is, CEO of the HCLA. So I'm going to pass the mic over to him to say a few words before we get started.
Liz, thanks very much, and thanks to the team at Lyles Parker. As Liz said, I'm Dr. Warren Hebert. I'm CEO with the Home Care Association of Louisiana. And we do a few things like this, a series of things that try to add value to your membership as part of the Home Care Association of Louisiana. And just want to again, take the opportunity to thank the team at Lyles Parker for doing this series of monthly webinars for us. And today, we want to thank Les and Ashley for being with us to talk about the False Claims Act and its impact on home health and hospice. So thanks so much for being here. We really appreciate you and the work that you all are doing out in the field. And again, thanks to Lyles Parker.
Great, thank you, Warren. As Warren mentioned, today's webinar is the False Claims Act and its impact on home health and hospice agencies. And today's presenters are Lyles Parker attorneys Ashley Morgan and Lester Johnson. And I'm going to give you a quick bio on each of them before I pass the mic over to them. So Ashley Morgan is a partner in Lyles Parker's DC office. She focuses her practice on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Ms. Morgan represents healthcare providers across the country in connection with a wide variety of health law issues, including coverage disputes, documentation concerns, compliance issues, medical board complaints, and exclusion and termination issues. She's worked with an assortment of providers, including home health companies and hospice agencies. She is a certified professional coder, a certified medical reimbursement specialist, and a certified medical compliance officer. Lester Johnson is a partner at the Lyles Parker, Louisiana office. He is a supervising attorney for the firm's, Baton Rouge office. In addition, he's also co-leader of the firm's health law practice group. Les helps clients navigate the myriad of regulatory, compliance, and business issues facing today's healthcare providers and practitioners. His core areas of practice include handling Medicare and Medicaid appeals, Medicare and Medicaid participation, and compliance issues. Quick reminder before we start, if you have any questions throughout the presentation, please feel free to type them in the chat box and we'll address as many as possible at the end of the presentation. And without further ado, I present you the speakers, Ashley Morgan and Lester Johnson.
Thank you, Liz, and thank you all for being here with us today. As Liz stated, Les and I are going to be speaking about the False Claims Act and its impact on home health and hospice agencies. Liz, can we go ahead and go to the next slide? So just a brief disclaimer. The information that we are providing today through this webinar is just general information only. It's educational in nature. While Les and I are attorneys, we are not your attorneys specifically. The presentation today should not substitute for legal advice. Outcomes in every case vary significantly based on the specific facts of that case. So for specific legal questions, you should reach out to your own healthcare attorney. Next slide. Okay, so an agenda for our conversation today. We're going to start out with a discussion of the current federal investigation and enforcement efforts. And then we're going to talk about some cases against home health and hospice agencies, their owners and staff, go through some sources of audits and fraud investigations, talk about the legal overview and some common statutes cited in FCA cases, and then some non-kickback, some non-anti-kickback cases, and then some final considerations. Next slide. Okay, so just a general overview of the current federal investigation and enforcement efforts Federal and state law enforcement strike forces have been actively working and very vigorously working, I will say, to prevent and combat healthcare fraud, waste, and abuse. There are several strike forces across the country. They represent a partnership between the criminal division, the U.S. Attorney's offices, the FBI, HHS, OIG, and the DEA. There are several strike forces, and you'll see on the screen here, there is one specific to Louisiana and Mississippi. It focuses mainly on Baton Rouge, New Orleans, and Gulfport. There are other ones as well for other areas that are identified as hot areas for healthcare fraud, including in Texas and the Houston, Dallas, San Antonio area, Florida, and the Miami, Tampa, Orlando area, and in other parts of the country as well. You know, in the northern part of the country, we have Newark and Philadelphia, and New York and New Jersey, and Brooklyn and New York. There's also a District of Columbia base up here in DC where I am that focuses on a national rapid response strike force. But it's important to know that there are specific regional offices across the country that are focusing on areas that have been identified in the past as ripe for healthcare fraud and abuse. Next slide. So this is an enforcement overview as of the beginning of this month. There was a 2025 National Healthcare Fraud Takedown. $14.6 billion was the intended fraud loss that was charged. That's how much money the government thought that it lost through this takedown and the individuals that it's trying to hold accountable. 15.6 million of those dollars were related to pills of controlled substances that were illegally distributed. 245 million cash and other assets were seized as a result of this takedown. Criminal enforcement, there were 324 defendants charged. Of those defendants, 96 were medical professionals. So almost a third of the total individuals that were charged in this one takedown were medical professionals. On the civil side, there was $48.6 million in settlements and charges, and there are 126 defendants. And the takedown covers 50 federal districts across the country. So it's a very significant takedown. A takedown is essentially, they post them on the Department of Justice website typically, and it's a big concentrated effort to announce a large, essentially enforcement action against numerous individuals, all different types of cases across the country. That's kind of put together into a one press release announcement of this big enforcement effort, and then they call it a takedown, and they outline each of those cases online. And there are details about each of the specific cases involved in this takedown on the online, on the Department of Justice website. Next slide. So enforcement efforts have been accelerating post-COVID. We're still seeing a heavy presence of fraud investigations. Since COVID, it's continued to tick up. Settlements and judgments from civil cases involving fraud and abuse claims against the government exceeded $2.9 billion in fiscal year 2024. Of that amount, more than $1.67 billion, so over half, was attributed to healthcare related cases and matters. So healthcare continues to be a huge area of fraud and abuse efforts, cases that are being brought, recoveries that are being pulled back from the government are coming from healthcare specific cases. So healthcare companies are definitely under the microscope. Home health and hospice agencies, which receive a lot of federal dollars, you are always going to be a heavy target for these types of investigations, purely because of the fact that many of the dollars that are received by home health and hospice agencies are in fact federal money. It's just purely based on the patient population alone. To go through a little bit of a timeline for you, in 2019, there was $3.1 billion in civil fraud recoveries. 2020, this went down to $2.2 billion. Things slowed down some because of the COVID pandemic. Fraud enforcement efforts were decreased a little bit to give some relief to healthcare providers. 2021, however, ticks back up to $5.6 billion. So They went after everybody they had wanted to go after in 2020 and everybody they wanted to go after in 2021. 2022, we go back down to a more standard number that was seen previously, 2.2 billion. 2023, 2.68. Last year in 2024, we ticked up to 2.92 billion. So significant amounts of civil fraud monies being recovered in these types of cases. During fiscal year 2024, 979, which was a record number of whistleblower cases, were filed. This is a significant increase over the 757 cases that were filed by whistleblowers in 2023. We're going to talk more about the False Claims Act later in this presentation, but just as a brief overview, a whistleblower is somebody who brings a civilian who brings a case on behalf of the government. Essentially, they blow the whistle on a company. Typically, they're a disgruntled employee who's filing a case against a healthcare company for violations of the False Claims Act, and the government has the opportunity to intervene in these cases and take on the case based on the facts presented by that whistleblower. In the first 2 months of 2025, the government had already settled 2 whistleblower cases totaling $878 million. So we're looking to see fiscal year 2025 also have significant recoveries. Next slide. Okay, some cases against home health and hospice agencies, their owners and staff, just to give y'all kind of an idea and to demonstrate the areas that the government's looking at and the schemes that they're looking into and the people who are being held accountable. The first case we have is out of Houston, Texas. In that case, a husband and wife who owned a home health agency both pled guilty to conspiracy to commit healthcare fraud and were sentenced to prison. The husband was sentenced to 12 months in prison. The wife was sentenced to 48 months in prison. The wife was alleged to have obtained patient referrals by paying kickbacks to marketers and patients and bribing physicians to authorize medically unnecessary home health services for the agency's patients. She also admitted to billing Medicare for over $8 million in fraudulent claims for home health services. The husband admitted that he had filed a fraudulent cost report to Medicare and attempted to disguise the kickback payments his wife made as legitimate business expenses. You know, we talk a lot about kickbacks and marketers and how important it is to paper those contracts. This is still an area that we see come up in fraud investigations all of the time. It's an area that the government is very interested in and still heavily prosecutes, and it's still rampant across the country. So it's very important that you make sure you're in compliance with any safe harbors if you are, you know, utilizing marketers for your home health or hospice agency. Another case out of McAllen, Texas, South Texas. The medical director of a large hospice and home health chain was sentenced for his role in a scheme that involved the submission of over $150 million in false or fraudulent claims to Medicare for hospice and home health services. According to the government, the company falsely told patients that they had less than 6 months to live. They were also sent chaplains to the patients based on the false pretense that they were near death. The company made payment of their medical director fees contingent upon an agreement to certify unqualified patients for hospice, and the defendant received luxury trips, bottle service at exclusive nightclubs, and other perks in exchange for his certification of unnecessary hospice patients. So some egregious facts here. The government's always going to, you know, be interested in a case with kind of, you know, salacious facts like that about the specific, you know, kickbacks violations. But the important note here is the medical director arrangements. If you have medical directors, best to have a medical director that doesn't refer any business to you. But if you do have medical directors, you need to make sure, you know, you're paying them fair market value and that they're accounting for their time. Next slide. Another case out of Houston, Texas. The owner of a home health agency was sentenced to 57 months in prison after being convicted of conspiracy to commit healthcare fraud. In this case, the defendant was alleged to have caused the agency to bill Medicare for home health services that were not medically necessary and not provided, and 2, paid medical clinics for fraudulent home health certifications and unlawfully paid for patient referral. So again, anti-kickback violations there. Second case out of McAllen, the owner of a home health agency was sentenced to 45 months in prison after being convicted of conspiracy to commit healthcare fraud. The defendant here was alleged to have submitted false and fraudulent claims to Medicare for reimbursement of home health services that were not provided, that a physician had not authorized, or were not medically necessary. And two, for paying for illegal kickbacks in exchange for patient information, including patient Medicare numbers. He and his co-conspirators then used that fraudulently obtained information to submit claims to Medicare in order to receive reimbursements. Next slide. January 2022, I have a case for you out of Michigan. In this case, an individual was sentenced to 9 years in prison for orchestrating nearly $2.8 million in healthcare fraud and wire conspiracy, and engaging in money laundering, aggravated identity theft, and witness tampering. According to the government's allegations, despite being excluded from billing Medicare, an individual purchased a home health company using the name, signatures, and personal identifying information of others to conceal its ownership of the company. And then in a 2-month period, he and his co-conspirators billed and were paid nearly $2.8 million by Medicare for services that were never rendered. And then the owner transferred these funds through bank accounts belonging to shell corporations and eventually to overseas accounts. So again, very egregious facts here. Using a straw man to participate in Medicare as an excluded provider, and then just making up services. That's a pretty extreme case, but that does happen. And it is obviously something that the government will look into and prosecute. January 2024, out of Arizona. In this case, a home health care agency operating in Arizona and 8 other states agreed to pay nearly $10 million to resolve allegations that it violated the False Claims Act by submitting false claims to a health care program administered by the Department of Labor for the benefit of Department of Energy employees and their contractors with occupational related illnesses. According to the government, in this case, between 2017 and 2021, the home health agency falsely billed the federal health care program for in-home nursing and personal care when its employees were not physically present in the patient's homes. The home care agency also paid kickbacks in the form of cash payments up to $5,000 for patient referrals through a friends and family program, and also were providing in-kind payments for food, internet, travel, and other expenses made to the patients and their families. This case actually originated from claims of a former employee who was employed as a corporate administrator and director of Human Resource Administration and Management. So a whistleblower here, obviously reporting this conduct that was then investigated by the government. But again, pretty egregious facts here. You can't pay for referrals, can't provide other sorts of remuneration to patients or their families. And obviously, it's important that we're documenting, if we're going in somebody's home to provide services, that we're accurately documenting when we're in those homes and billing for the days of service that we're actually providing the services. Next slide. Okay, another case for you out of the Northern District of Illinois. 2 owners at issue in this case. The first owner owned several home health agencies and allegedly maintained relationships with marketers and signed sham contracts with paid patient marketers on behalf of the companies, while another owner was alleged to have facilitated kickback payments to marketers by writing checks to himself and agency employees, who would then convert the checks to cash that was used to pay kickbacks to marketers. Owner 1 caused fraudulent claims to be submitted to Medicare for home health services that falsely represented that she, as a registered nurse, performed assessments of patients on dates when she was out of the country. It was the practice of the owner's companies to admit, discharge, and recertify certain patients repeatedly, regardless of their medical conditions as well. We do see that come up in cases, billing for services when you're out of the country. Obviously, that's problematic, and it's pretty easy for the government to investigate and prove, because there's records of flights and being out of the country, and especially if you're leaving the country, you know, there's visas that they can look at, but that does come up in these cases, and we do see that more often than you would think. Another case out of the Southern District of Florida, a marketer pled guilty to 1 count of conspiracy to commit healthcare fraud. According to court documents, the marketer and his co-conspirators were paid kickbacks to Medicare beneficiaries to recruit them for referral to home health agencies. The marketer also coached the Medicare beneficiaries who did not need home health services on what to say to obtain home health prescriptions from doctors. In exchange for referring these beneficiaries, the marketer solicited and received kickbacks and bribes from home health agencies. The individual and the home health agencies attempted to disguise the kickbacks and bribes by routing them through shell companies that were controlled by the marketer. Another case out of the Northern District of Illinois. In this case, a healthcare consulting company, which was based in Pakistan, had been engaged to handle the Medicare billing and EHR maintenance for 20 home health agencies in Illinois, Indiana, Nevada, and Texas. While working at the company, one individual allegedly caused the agencies to submit fraudulent claims to Medicare for home health services, which resulted in over $40 million in payments for services that were never rendered. Next slide. A few more example cases for you. This one is out of the Central District of California. The administrator of a Southern California hospice was sentenced to 30 months in prison for his role in a multi-million-dollar hospice fraud scheme. As a part of the guilty plea in this case, the defendant actually admitted that while acting as administrator for a hospice that was located in Downey, California, he and others were paying illegal kickbacks to patient recruiters for the referral of hospice beneficiaries to the hospice agency. In addition, when the clinical staff at the hospice determined that the beneficiary referrals did not qualify to receive hospice services, he was overruling those determinations and nonetheless put those beneficiaries on hospice service. Another case out of the Southern District of Texas. There's a lot of cases out of Texas. It's been an area that's been on the government's radar for a long time. In this case, there was an operations manager for a chain of hospice and home health agencies throughout the Rio Grande Valley that was sentenced to 27 months in prison in order to pay $4.7 million in restitution for his role in a conspiracy to falsely convince thousands of patients with long-term incurable diseases that they had less than 6 months to live in order to enroll those patients in hospice programs, which they were otherwise unqualified for, to increase revenue to the company. At the trial of his co-defendants, witnesses were testifying that the vast majority of the hospice and home health patients at that group of agencies did not qualify for services. The government specifically alleged that the physicians were being bribed with illegal kickbacks under the pretense of medical directorships. Physicians were falsely certifying unqualified patients for services, and employees were instructed to falsify medical records, making non-terminal patients appear to be terminally ill and declining. You know, again, very, very bad facts here, conduct that you would hope, you know, you wouldn't see in individuals who are, in general, let alone individuals who are working in the healthcare field. But these things do happen, and government, you know, knows this and heavily investigates and prosecutes in this area. Next slide. Okay. So what are some sources of audits and fraud investigations? There's a lot of different ways that the government can find out information for an investigation. Sometimes it comes from an audit. CMS requires a UPIC, which is a Unified Program Integrity Contractor, to store the most recent 36 months worth of data for home health and hospice agency claims. One thing the government is very good at is collecting data and storing that data and utilizing that data. These UPICs then use that data along with other data sources to identify outliers and potential audit targets. This is called predictive modeling or data mining. And some other factors that are also considered are, in addition to the claims data itself, is the volume of business that provider has, and if it's changed, the percentage of Medicare and Medicaid patients, if there's been a history of prior investigations, error rates, which if there were audits in the past, how well did the agency perform on those audits? Were most of their claims approved? Were most of them denied? Were any of them overturned on appeal? Those are all things that they look at. Does the agency have a history of overpayments that have been requested to be returned? And does the agency challenge any of these decisions? And if so, are they successful on appeal? There are some other sources as well. Those can come from just complaints, whether those are from beneficiaries, physicians, other agencies, disgruntled and former employees. Those many times can be, reported to OIG has an anonymous tip line where complaints can be reported. Also, obviously, there are the whistleblower complaints that can be filed in court that we'll talk some more about. Referrals. Audits and investigations of healthcare fraud are often based on referrals from other contractors. There are the UPICs, there are the SMRCs, the MACs, the state MFUCUs, other enforcement entities. Private payers also refer cases to the government. There are reports that the OIG and the GAO regularly issue addressing areas of concern. These often indicate areas that are going to be investigated further. So I recommend keeping an eye on those. State licensing boards, medical boards, nursing boards, pharmacy boards can also refer cases for further investigation. But it's important to keep in mind that I know a lot of providers are familiar with UPIC audits and private payer audits, and it's important to know that these entities all meet and talk about their cases, what they're seeing, things that are being investigated, and all of those audit cases can be referred to the Department of Justice or to the OIG for fraud investigation if it does appear that those cases should be elevated. So that's always a way that these cases can start out. So you should never get a UPIC records request and just, presume that it's just purely going to be an administrative matter. Next slide. So, like I was just saying, there is actually language in the Medicare Program Integrity Manual, which instructs the UPICs to refer potential cases to the OIG. They want the OIG to receive these cases. They want to make sure immediate action is being taken to protect the Medicare Trust Fund and ensure that payments are not being improperly paid out. If a non-UPIC contractor identifies evidence of fraud and abuse, they are also directed to refer cases that involve fraud and abuse. There's actually language as well for that. Contractors shall analyze provider compliance, Medicare coverage and coding rules, and take appropriate corrective action when providers are found to be non-compliant. For repeated infractions or infractions showing potential fraud or patterns of abuse, more severe administrative action shall be initiated. At any time, evidence of fraud shall result in the referral to the UPICs for development, and then the UPICs can obviously refer to the OIG. Home health and hospice MACs, your Medicare administrative contractors, are required to refer potential fraud, waste, or abuse situations promptly to the responsible UPIC, forward complaints alleging fraud through the screening staff to the UPIC. So a lot of times when a UPIC initiates an audit, they'll go and talk to patients, and when they're looking at those reports, they can take information from there and use it as a part of their referral. Forward to the UPIC detail documentation of telephone or personal contacts involving fraud issues discussed with providers or suppliers, and to retain such information in individual provider or supplier files. So you should never presume that just because you have a SMRC audit or a TPE audit where you're just talking to, the medical review staff, you should never presume that everything is always just going to remain that way. These other contractors are tasked with referring conduct, and that can be referred to the UPICs, which can then be obviously referred to the OIG or to the Department of Justice for fraud investigation. Next slide. Okay, so while I say that, primarily, if you get a UPIC letter, should you immediately panic? No, I don't want you to immediately panic. Primarily when we see a UPIC records request, That's typically going to result in the UPIC asking for records and identifying an alleged overpayment. That's typically what we see. If that's not the course, then we do see that there are other courses of action the UPIC can take. Sometimes we see that result in a suspension action against Medicare or Medicaid, where they cannot get paid for the services. Well, they will eventually if there's not an overpayment. But the money that would be paid for the services that they're providing during the suspension period are all put in an escrow account, which are then applied later to any overpayment that results from an audit. There's also the ability to have the MAC revoke the provider or supplier's Medicare billing privileges based on audits. There's a revocation authority based on a pattern of practice of billing errors. So that's another action that could happen administratively. And then again, while it's not as likely as the other options, they absolutely can refer cases to law enforcement for civil or criminal prosecution. Next slide. Okay, and now Les is going to talk about the legal overview of the False Claims Act.
Hello, everyone. Hope y'all can all hear me. Yeah, again, so I'm going to start with the boring part of the presentation. We're going to talk about the laws and all the tools that they have to punish instances of healthcare fraud. Starting out with the Civil False Claims Act, this was passed in 1863. It's called Lincoln's Loan. It was mainly for profiteering, but among its main provisions is measures intended to encourage the disclosure of fraud by private persons by the filing of KTAM lawsuits. The term KTAM is Latin. It means essentially he who brings a case on behalf of the king. So the KTAM relator is essentially bringing a case on behalf of the federal government and themselves to get a potential share of the recovery. We call them whistleblowers, but it's a really frequently used tool in the fight against healthcare fraud and abuse. It's lots of times the government learns their cases through whistleblower complaints that are filed. Let's go to the next slide. All right, so the False Claims Act. So 31 USC 3729 to 3733, it makes it imposes civil monetary penalties and damages on any person who knowingly submits or causes to be submitted a false claim to the government for payment. The term knowingly doesn't mean just actual knowledge. It includes reckless disregard or deliberate ignorance. So you can't just ignore the payment rules and coverage provisions that are applicable to your services. The statute of limitation is 6 years, but it can be told up to 10 years in some cases from when the government knew or reasonably should have known that the violation occurred. You can expect, where they need to, they're going to try to stretch that as far as they could. So, I don't like to have clients ever really relying on the 6 year limitation. The 10 is what potentially could occur if they claim that they didn't know or shouldn't have known about the false claim. Damages have been increased recently. Now the minimum is $14,308 per claim, up to $28,619. Sometimes the penalties that they'll ask for in Civil False Claims Act cases are just comically high, just astronomical sums, and it's because they'll submit, 1,000 claims or 1,200 claims or 400 claims, and they'll pop, potentially up to $28,000 per claim. Even at 14, obviously, it would be astronomical figures. Let's go to the next slide. So, when they're investigating these cases, when we talk about the discovery process, lots of times now they're using civil investigative demands, which is basically just essentially a subpoena, but in a Civil False Claims Act investigation. But they'll also have lots of times a parallel criminal investigation going on. And this can be the same way with UPIC audits or any other kind of audit you've got going on or investigation. Sometimes the criminal team at DOJ is sitting there watching those proceedings play out. So it's permissible for them to have both civil and criminal investigations going on at the same time, and they'll try to take advantage of that, where they can. So one of those ways is compelling you to provide oral testimony in a civil investigative demand case. So they can demand under 31 USC 3733H oral testimony or production of records, and they can require you to come in and testify. Obviously, the government can't compel you to violate, they can't violate your Fifth Amendment rights to and compel you to provide self-incriminating information. So, but at the same time, they're going to claim that it's a civil case, and maybe you don't have the same rights. DOJ is always trying to push the lines there. And one thing they may do is, if you do assert your Fifth Amendment rights and you decide not to provide any testimony because this isn't, or in this particular instance, their investigation wouldn't be in connection with a criminal matter, they may ask the court to issue an adverse inference if it ever proceeds to litigation. So all this is kind of dicey when you're responding to a civil investigative demand that has either interrogatories or ask for testimony, because you never know who they're targeting. And they could be targeting you in order to just gain leverage over you in order to get at your boss or whoever. Regardless, you want to have an attorney kind of advise you on all this, because in a civil case, you can end up with adverse inferences. So, plus, you always want to cooperate with the government if you can, but it just becomes really dangerous whenever they take the step into issuing like civil investigative demands, because there very well could be a criminal parallel proceeding going on, our investigation. Go to the next slide. So, stepping over to the criminal side, the federal anti-kickback statute is really, really commonly used tool in the DOJ's toolbox. It was enacted in 1972. Under this statute, it's a crime to knowingly and willfully solicit, receive, offer, or pay any remuneration, which is basically anything of value, in return for referring or arranging for the services payable by any federal or state healthcare program, or purchasing, leasing, ordering, or arranging for any goods or facilities or services that may be paid in whole or in part by any federal or state healthcare program. So this applies to more than just Medicare. It's Medicare and kind of indirectly Medicaid, Medicare Advantage, VA patients, I think American Indian Health Plan patients, I believe, are covered by that too. So it's a lot of different kinds of patients. It's not just Medicare, but under the Affordable Care Act, they amended it to, I guess, clarify what some courts were requiring at the time. They were saying that a person need not have actual knowledge of this section or specific intent to commit a violation. So this is essentially lessened the requirements needed for the government to bring a criminal case and a kickback statute. We used to always say how high the intent standard was, and it would kind of scare them away from these cases. But that amendment under the Affordable Care Act made it a lot easier, and it basically just brought the statute in line with some of the courts that were, I guess, we're interpreting it this way already. Then in the under the Bipartisan Budget Act of 2018, criminal penalties were increased to $100,000 from just $25,000, and maximum sentences for felonies under the anti-kickback statute were increased from 5 to 10 years. Lots of times they will stack charges in a criminal case, so there'll be an anti-kickback statute violation, and also, criminal or whatever false claims act violations. They could also have healthcare fraud statute violations. All those will have different penalties, and so lots of times they can stack the potential incarceration, years up to asinine amounts. Sometimes just like the penalties under the Civil False Claims Act. So, it's never look at one of these charges and say, oh, it's only 5 or 10. Some of these charges are actually 20 years. So it's obviously, once you lose your freedom, it's serious anyway. 1 year is serious, but all of these statutes are pretty harsh. So always keep that in mind with everything you do in working in healthcare. The penalties are very severe. Let's go to the next slide. So the Federal False Claims Act and the Federal Anti-Kickback Statute and the False Claims Act were long kind of viewed as separate, because one's criminal and one's usually, there is a criminal False Claims Act statute, but usually they would use Civil False Claims Act proceedings in some cases, and anti-kickback would be for the really bad criminal situations. Over the past 20 years or so, it started to kind of change, and they would typically be pursued as whistleblower asserting violation of False Claims Act. That would typically be a criminal anti-kickback statute violation. So lots of times they involve fact patterns where the parties alleged to have violated the statute and both this anti-kickback statute and in the process allegedly billed for worthless or worthless services, or basically made an implied certification that everything complies with the law, but obviously with the kickback it doesn't. So we kind of come up with these implied False Claims Act cases. But in 2010, the Affordable Care Act got rid of the need to bootstrap any violations of an anti-kickback statute violation onto False Claims Act. So now any violation of the anti-kickback statute is now automatically a false claim for purposes of the False Claims Act. So essentially your penalties can get up much higher than just what the anti-kickback statute would penalize you on, because any violation of the anti-kickback statute, which you can be punished for, is also a separate violation of the False Claims Act. So you can get those penalties as well. Go to the next slide. So safe harbors. Anti-kickback statute is an intent-based statute, so not everything, not everything that it might describe in its really broad terms are, or even want, even does, the government doesn't even want a lot of these things to be considered illegal. They're ordinary, normal practices in healthcare. But in a lot of this, Congress enacted 11 statutory safe harbors, and they also authorized HHS OIG to issue more safe harbors themselves. So now there's a total of 38 regulatory ones as well. These are voluntary little rules that essentially say if you or your situation, so your contract or your agreement, if it complies with all of the elements of the safe harbor, then essentially the arrangement will not be subject to scrutiny by the OIG or DOJ. So lots of times an arrangement won't quite meet all of the elements of a safe harbor, but it's still not considered illegal. It's just that you don't have this affirmative defense, and you can't basically just point to the fact that, oh, we're safe harbored, you can't look into anything. They can investigate the entire arrangement and look at a kind of facts and circumstances analysis to figure out if they think you violated the intent of the statute. Let's go to the next slide. One of these safe harbors that's one of the most commonly used one, and lots of times the contract may not completely comply with it, but what you would try to do is at least comply with as many provisions of it as possible. But there was a recent change in December 2021 to this one, where one of the rules is that the aggregate compensation, meaning the entire amount that'll ever be paid over the entire agreement, had to be set out in writing in the agreement. So every dime that was ever going to be paid had to be written right there in the contract. And that was impossible for lots of contracts where, say it's hourly or there's just any indeterminate amount. So the way Stark law, which is a separate civil law that deals with payments for referrals, which is very similar to anti-kickback, it had a personal services and management contract exception under it, and it always only required the methodology to be set in advance, not the exact amount paid. And so what this amendment in 2021 did is essentially made the anti-kickback safe harbor consistent with the Stark law exception for the same kinds of contracts. These are basically any contract with an independent contractor, as opposed to an employment contract, would be protected under the personal services and management contracts safe harbor. Anyway, so now only the methodology has to be set in advance, which is much easier. Lots of agreements could be a safe harbor solely on that basis. And it wouldn't mean we would stop them from moving forward if that was the only thing that, was problematic, but, or if we could build in other safeguards. But specifically about, I guess, this safe harbor in Action General remuneration doesn't include payment by a principal to an agent as compensation for the services of the agent, as long as the following standards are met, and here are the terms. It's got to be set out in writing, assigned by the parties. It's got to cover all the services the agent provides to the principal for the term and specifies those services. So it can't just be one big giant for all services rendered kind of clause. It's got to actually list out the things that they're going to be doing. The term's got to be for not less than 1 year. Methodology for determining the compensation is, quote, set in advance, consistent with fair market value in an arm's length transaction, and is not determined in a manner that takes into account the volume or value of any referrals or other business generated between the parties for which payment may be made by Medicare, Medicaid, or another federal health care program. And then the services can't be performed can't involve the counseling or promotion of a business arrangement or other activity that violates state or federal law. This one, I haven't seen very many prosecutions ever allege that you didn't violate this. I mean, you violated this part, and that was it. And then the final one is the aggregate services contracted for do not exceed those which are reasonably necessary to accomplish the commercially reasonable business purposes of the services. This would be like a situation where there's a lease agreement between, say, a referral source and a referrer, and the amount of square footage leased is like some shockingly large amount that they don't need, and it's basically just, I'm going to lease all this space from you as a form of a kickback. I don't need that much square footage to accomplish my commercially reasonable business purposes. That would be, I guess, a situation where it may violate just that. So let's go to the next slide. But anyway, as you can see, there's a lot of different requirements, and sometimes you'll not, meet one of them. All we'll do is we'll meet as many as we can and build as many other safeguards as we can into the arrangement and kind of move forward if we think the risk is low enough. As opposed to independent contractors, there's also an employment safe harbor, which is much simpler. It just says that there's no violated statute for any payment by an employer to an employee who has a bona fide employment relationship with such employer for the employment and the provision of covered items or services. So Fifth Circuit recently basically said that it's the common law definition of agency and employees that it controls from basically that's codified in 26 U.S.C. 3121 D2. But basically they're going to look at the kind of a facts and circumstances analysis to see, the hiring party's right to control the manner and means by which the project is accomplished, the skill required, the source of the instrumentalities. Does the person bring their own tools and knowledge and whatever into the job? Do they set their own hours? Where do they work? That sort of thing. It's basically the same kind of analysis that would apply when you're trying to find out if someone's an employee or an independent contractor for tax purposes. That's kind of what they're going to go by. Let's go to the next statute. But as you can see, there's way less rules for this. It's just any amount paid to an employee who, as long as there's a bona fide employment arrangement. Fair market value. This is really where a lot of people will get in trouble, especially hospices and home healths, with say their medical directors or their other physicians that are working for them. There was a 2015 fraud alert on physician compensation arrangements. Of course, they've warned about this 1,000 other times as well, but this is one they're talking about. They had recently reached settlements with 12 individual physicians who entered into questionable medical director and office staff arrangements. So in these cases, they alleged that compensation paid to the physicians under the medical directorships for improper remuneration under the kickback statute because they either took into account the physician's volume or value of referrals, or they didn't reflect fair market value for the services to be performed. So they would actually look at the amount paid versus what are the duties of the medical director. And I find in medical director agreements that's a big key. Like some medical directors get paid a ton of money, but they're asked to do a lot of work, like work on the floor all day, every day, in say a psych hospital or something. And then some medical directors are just there for a couple hours a week and some basic general supervision and basically turning up for monthly meetings to revise policies and things like that. Those people ought to be paid a hell of a lot less than a really, really active medical director. So it really depends on the amount you're paying for the services that are actually being rendered. And it could be very different in different settings. But sometimes I've seen $200,000 medical directorship agreements, and I've seen $15,000 ones or $12,000. So it can really run the gamut, but it depends on what are they actually being asked to do. Sometimes they're not actually providing the services called for into the agreements. You can have a risk area there if you put too many just fluff duties in there and you don't actually expect them to show up to weekly meetings or whatever. Only put in your contracts what you're actually expecting the doctor to do and make sure that they actually do those things. Also, lots of times with medical director agreements, we'll have timesheets and they'll have to turn those in saying what they did each month in order to get paid. It's not always necessary, but it's a good idea. They also allege that some of the 12 physicians enter into arrangements under which affiliated healthcare entities paid for the salaries of their front office staff. So basically, home health or hospice was paying for I guess, what they would probably pitch it as is like, intake staff for the hospice, but really they'd just be working for the physician, but they would, I guess, that's probably the way they would paper up and try to hide it. But essentially, they were just paying for the secretaries and front office staff at a doctor's office, and that saved them money. So they would send their patients to that hospice or their home health. It relieved the financial burden that they otherwise would have incurred. And so, it's not just straight kickbacks. Sometimes it's things like that. If you're paying for something that someone above, one of your referral sources otherwise would have had to have paid, then that's something of value. That's remuneration you're giving to that physician. So that relationship needs to be analyzed and needs to be protected if it can, and if not, it needs to be ended. Let's go to the next slide. I'm kind of getting behind a little bit. All right, so recent areas, examples of problematic conduct. So just be careful anytime you're entering a business arrangement with anyone who has the ability to refer business to your practice or your company. This can be not just straight, clear refers like a physician, but it could also be any arrangements you have with discharge staff at some place that could be obviously problematic, or any of their spouses or anything. You just want to look at all your business arrangements with anyone who has the ability to send you any business. Lease arrangements with referral sources, like I said earlier, working as medical directors, very common, and you have to have them, right? But your medical directorship agreements should be similar to other hospices or home healths. And it should be, the amount you pay them should be directly related to the amount of work they're actually having to do. It shouldn't just be a paycheck, just a check they collect and they don't have to do anything. Sometimes you'll have, people that are coming in and bringing lunch in. This is, drug reps, obviously. They've always done that. That's all commonplace and still fine, but, extravagant meals and vacations and things like that are problematic. Sham arrangements to give members of your agency or your owners or whatever speaking fees and grants and things like that. Those can all be problematic. You can also violate the anti-kickback statute by giving, and other statutes as well, but the anti-kickback statute by giving cash and gifts like that to patients for signing up or recommending healthcare services. So, or to any referral source really. So sporting events, gift cards, all that sort of thing can all be problematic. There are safe harbors that can protect normal marketing activities, but you can easily step over the line too. Next slide. All right, so there are also this is the generic healthcare fraud statute, 18 U.S.C. 1347. It just essentially says it's unlawful for any person to knowingly and willfully execute or attempt to execute a scheme or artifice to defraud any healthcare benefit program or obtain it by false pretenses any money or property owned or under the control of the healthcare benefit program. By benefit program, basically, I mean insurers or anything like that. But this statute is unique in that it applies to both government payers and private healthcare insurance. So like Blue Cross Blue Shield is covered by this and protected by it. Any attempt to defraud them by, altering records or whatever, and not complying essentially with your provider agreement with them can result in, I think I just lost the event, can result in action. Can we bring that back up?
Sorry, give me 1 second. Let me get the right PowerPoint. I don't know what happened. It just sort of shut down.
We're still on.
This is the right PowerPoint.
Let's see where it was. Healthcare fraud. So another one besides a generic healthcare fraud statute, and I guess you can just bring this up whenever you get a chance, is obstruction of a federal audit. This is 18 U.S.C. 1516, says whoever with intent to deceive or defraud the United States endeavors to influence, obstruct, impede a federal auditor in the performance of official duties relating to a person receiving in excess of $100,000 in any given year, basically. Federal auditor would be any of these people. You pick auditors, anyone who's auditing any of your claims or your services on behalf of the federal government. So it's all the Medicare, Medicaid auditors, essentially. They also have things like just obstruction of a federal investigation and lying to the lying to federal official laws that they can use. And basically all these would be any alteration of records turned in for an audit or lying to them when talking, all those kind of things fall under these types of laws. I guess they would direct target healthcare fraud. They target how you respond to them, essentially, and how you respond to their investigations. Lately, we'll go to the next slide when you get a chance. There's aggravated identity theft has been used a lot, and so under the aggravated identity theft statute, it basically whoever during and in relation to certain felonies knowingly transfers or possesses someone's identification shall be sentenced to a term of 2 years. So they have all these different predicate offenses, and some of them are false statements, healthcare matters, healthcare fraud, wire fraud, or mail fraud. So basically, what they're doing is tacking on an identity theft charge. If you, for instance, were committing healthcare fraud using someone's a Medicare patient's Medicare number and ID or whatever. The Supreme Court did kind of limit that and said that it has to be the person's means of identification has to be why the claim was paid. But just know that I guess they're just, like I said, they will tack on every charge they can if it the facts fit the crime. So aggravated identity theft is also something just to be tacked on top of the rest of your charges. Here in the next statute, in the next page. Then there's the Criminal False Claims Act statute. Remember earlier I said there's both civil and criminal false claims acts, but this one just says whoever makes or presents to any person or officer in the civil, military, or naval service of the United States or to any department or agency thereof, any claim upon which or against the United States, knowing such claim to be false, fictitious, or fraudulent. So very broad, but this is the basic criminal false claims act statement. Then there's 18 U.S.C. 1035, which is false statements involving healthcare programs. And it reads about how you would expect. If there's no statute that they can find that perfectly fits it, they've got a general catch-all that's just generally any false statements or entries. And it's falsify and conceal or cover up any material fact, make any materially false or fictitious statements, or make or use any false writing or document knowing that contain materially false or fictitious statements. All of these things like altered medical records are fall squarely within this, but they could also get you with false claims involving a healthcare program, or just the false statements, or just the regular Criminal False Claims Act, or civil. So they can, I guess my point is in bringing all these up is these are all citing and describing essentially the same conduct, and they can pick and choose which of these various crimes they would like to, I guess, prosecute you with. They can use both civil and criminal at the same time. There can be some complications when that happens, but basically, if they want to throw the book at you, they can. You do not ever want to be the target of the federal government. Go to the next slide. I guess along those lines, looking at this is a prior attorney general, so I'm not sure what the current administration would be like, but I bet they're similar because this is a pretty well-held belief in all of law enforcement. She's basically saying here that their first priority is to hold those accountable who commit and profit from corporate crimes, but they're also making clear that all individuals who engage or contribute to the criminal misconduct will be held personally accountable. And she talks about, provisions in officers' compensation programs, about clawback provisions and whatever. But the thing to really take from this is they will pop the biller, the marketer, the owner, the doctor, everyone involved if that helps their case. The only time, so the little guy doesn't get hit is when it, for whatever reason, benefits the DOJ or, OIG. It's not going to be anything they did. They will prosecute people that cooperate. They will prosecute people who don't. Just don't commit fraud for your employer and you'll be good. That's the main key there, because everyone can be personally liable. Go to the next slide. So we're really running out of time here, but non-kickback problems identified. So failure to document support medical necessity. Obviously, this is really, really common. You always need to make sure that your people are doing this and check it routinely, because sometimes people will be doing good 1 month and then they'll kind of fall down and stop documenting properly. You need to be able to pick that up when it occurs so that you don't have errors that go on for long periods of time. Failure to sign treatment notes, obviously you need to sign and close out each one of those. You've got licensure, requirements that would require you to do that anyway, aside from Medicare rules. But if you're going to document it, close it out and sign it. Missing treatment plans and consents. Obviously, sometimes these things haven't been dated right or whatever. You need to be picking up on these errors as they occur, so you're not finding out way after the fact. Allowing one big way to get in trouble is to allow anyone unlicensed to do anything. Don't ever do that. It's gonna look bad for you, not only to the payer but to the licensure agencies, to the feds. Every contract you've got is requiring you to have nothing but licensed people there. So sometimes they'll, through fraud, will try to sneak through and work for you anyway. But you need to have systems that are good enough to catch that. Next slide. Obviously, billing for services not rendered is a biggie. Don't ever do that. Sometimes there can be a mistake, but you need to have systems that are in place to catch those kinds of problems. Misrepresenting non-covered services. I find that this is usually intentional, and it's like billing for a scooter, a motorized wheelchair when you really gave someone a scooter. But essentially, characterizing non-covered services as covered. I guess it can happen in home health and hospice, but it's usually pretty blatant when I see this sort of thing. Misrepresentation of the provider providing medical service. This happens a lot. Sometimes someone's not properly credentialed or something, and you just throw someone, or they'll just throw someone else's, some other nurse practitioner or someone else's number down on a claim. Don't do that. Even when it's innocent, it's obviously wrong and inaccurate. You shouldn't be doing anything that's obviously wrong and inaccurate, no matter if you have a, legit or, it doesn't matter what your excuse is. Just try to be accurate on all your claim forms, and definitely don't ever misrepresent, who's providing the service, even if it's just to make a claim go through or whatever. Go to the next slide. I think this is just kind of a wrap up. Basically, just look at all your financial relationships with potential referral sources and any bigger contracts you have. Billing companies, things like that can also get you in trouble. Examine your leases, payment agreements with all your providers. Review your ownership structure if if anyone in the audience is ownership kind of group. Do you have any investors or sources of referrals? It's not the end of the world. And lots of times it can be structured and be fine, but make sure that you're looking at that periodically. Review all your policies and procedures and training for marketing and community liaison type staff. You definitely want them to be bona fide employees if you can. You do not want to pay them like per, admission or anything like that. Next slide. I think we're done. So get a good compliance plan. And if you do have to, if you're, just a regular employee in a company, this isn't your company. If you see something going on, what should you do? Should you continue working for them despite, knowing that something's wrong is taking place? No. Lodge your disagreement and then continue working? No. The only things that will protect you for sure is resigning and possibly resigning and filing a complaint. Just, don't complain about every single disagreement that pops up. But when you see something to be criminal, you do not want to become part of the problem. You can actually be charged under 18 U.S.C. 4 for not reporting certain things. So it's not used all the time, but the only safe way for you is to get out of situations that involve obvious criminality. So if you see it, leave and report whatever you got to report, but remove yourself from it. Do not be part of it for someone else. And that's it.
All right. Thank you so much to our presenters, Ashley and Lester, and thank you all for joining us this afternoon. We will be sharing copies of the PowerPoint slides later this week, and there are no questions posted, I don't believe, unless there's one that just got shared. Nope, it's more of a thank you message. So again, we'll see you next month. Bye-bye.
All right. Bye.
Thank you. Bye-bye.
Thank you.
Hey, Les and Ashley, Warren Abear here. Thanks again. We appreciate what you guys do for us.